Oshoma. Mr. Oshoma, thank you for joining us on Beyond the Headlines again. I'd like us to begin with the court's very first major finding. You had the justice saying that the plaintiffs failed to establish any cause of action, excuse me, capable of activating the Supreme Court's original jurisdiction. And on that basis, he struck out the suit. Break that down for us. What exactly did these states fail to do in this regard?
Yeah, you see, some of us as observers had observed also when that suit was filed that would be the first hurdle that the PDP governors would have to cross, because the issue of local standing had always been, a germane issue in most of public interest matters such as that. You remember the two previous cases that had gone to court, they also were defeated on the grounds of cause of action, right of action. And public interest matters are usually, determined, one way or the other in such ways. So in this case, what the court is simply saying is, look, you have not established, your rights that had been or would be violated by this action that was taken. And so to that extent, it becomes premature for you now to say that your rights, has been violated, that you need the court's protection on same. So you remember the one that had gone to court before, the Plateau's governor's case, when the state of emergency was declared in Plateau. What happened was the Attorney General, who also was suspended alongside the executive members that were suspended, approached the Supreme Court. And the court said, no, you cannot. There was a preliminary objection. And the court also ruled that the Attorney General, having been suspended from office, certainly he lacks the locus to come to court, to approach the court as an Attorney General of the Federation. So also, but the difference in that one was that the court, didn't go further beyond that. They didn't rule either way. But this case now, because of practice direction, in some cases, before now, if this matter were to be an appeal, the matter is appealed, and then the court will take the issue of jurisdiction or the issue of local standard and then now remit. If it is determined that the parties has, the right of action, then they can remit the matter back to the trial court, to conclude whatever business they have done. But in this case, because of amendment in the practice direction, the law now permits the higher court to determine the preliminary issues. After determining the preliminary issues, even if they rule against you, they still go ahead to determine the substantive case one way or the other, because it is a point of law. So that is what the Supreme Court had done in this case.
And that's very, very interesting, Mr. Oshoma, because after striking out the suit for want of jurisdiction, this court still went ahead to consider the substantive issues and dismiss the case on the merits. I think that you already threw light to that, because that's where many Nigerians may be confused. That is that standard judicial practice, or was the Apex Court deliberately seeking to give some form of finality to this constitutional question?
No, it is now a standard judicial practice that when, instead of, unnecessary delay, that when such matter comes up, even if the court decides the preliminary motions or applications, the court can still go ahead to decide, even though they had ruled against you or that the fact that you have no locus. But since it's a matter of law, the court, by practice direction, is still allowed to go into the substantive matter and rule one way or the other. And so that's basically what they have done. And they are completely in order. If previous Supreme Court had, similar latitude, we probably wouldn't have been here today. So the issue of whether the president had the powers or not will not be here. Even though I disagree with the judgment of the Supreme Court, I vehemently disagree with it. But even though others had,
it has happened again, Mr. Oshoma. I remember that your light went off in previous interviews. But if you can still hear me, we can cover your your image for a minute and continue this conversation. Are you still there, Mr. Oshoma?
Yes, we can do that so that I quickly put on the gen.
All right. So you know that Justice Idris held that Section 305 empowers the president to deploy extraordinary measures, and that the Constitution does not really specify what those measures are. Does this judgment effectively expand presidential powers in that regard, or merely clarify powers that were already implied but contested?
What has happened here is that the judgment, I believe, expanded presidential powers, because also if you look at section 188 of the Constitution on how a governor can be removed from office, it did not state in that section that subject to Section 305 of the Constitution. It didn't state there that subject to Section 305, and that which states that a governor can be removed by virtue of a declaration of a state of emergency because the powers are not explained. I think what the court basically had done is to extend the powers of the president to in a democratic dispensation. And if those powers, the fear is that if those powers falls into the hands of a dictator, then what we are seeing today might not be palatable, because it's still stated, if you look at, if you go down to what do you call it, subsection, if you look at the law and you look at the provisions of Section 305 clearly, and then you look at subsection 5 of Section 305, it clearly states that, if you permit me to read, because I've always stated this consistently, subsection 4, that the governor of a state may, within the sanction of a resolution supported by a two-thirds majority of the House of Assembly, request the president to issue a proclamation of a state of emergency in the state where there is in existence within the state any of the situations specified in subsection 3, C, D, and E of this section. And such situation does not extend beyond the boundaries of the state. So in this case, are we saying that the governor will invite the president to use extraordinary measures to remove him from office? That's the big question that the court also probably will never answer.
You know
so
that
because if you look at all of that, the emergency situations, emergency in some cases, even though we agree, it might not be all of the states. So because the court has said that the Constitution did not state clearly, the extraordinary measure that can be used. So if there is an emergency, for example, in Koshofe local government, does that mean there is an emergency in the entire state? And if these powers falls in the hands of a dictator, the dictator can decide to say, you know what, there is an emergency. And the Constitution says extraordinary measures. And the Supreme Court has said that since extraordinary measures is not clearly defined, and I can do and undo, and so I hereby declare state of emergency in the entire state and suspend all of the democratic structures in that state. So
I understand that.
That's why powers that are not contemplated within the democratic space.
I understand that